Today's presentation will be about will caveat proceedings. Thank you for joining. We'll start today by doing a quick question that we'll put out to our attendees, and we ask you answer that. Please give me a moment. We'll get that up for you. Question is, how long do you have to file a will caveat? A lot of times, especially in this area of work, our clients will come to us because something has occurred to them that is wrong after the fact. And it's not necessarily it's not necessarily that they're being derelict, actually, because many times our client will be the interested party who's challenging the will, and so they actually didn't know exactly what was going on with the estate. And so, having a little grace there for our clients to think, well, you knew the person passed away, you thought you were an heir in the will, or maybe thought there wasn't a will. And so perhaps it takes you a little bit of time to realize something is being done and you're not being included properly, right? And then they come to you and say, we need to challenge this document. All right. So the choices are 3 years from application of probate. There is no time limit, file it whenever you want, or 3 years after challenger turns 18. Okay, thank you. And it looks like 80% are saying 3 years after the application of probate. Okay, we're going to look at the statute in just a moment, and so put a pin in that. Another thing that well, a lot of things come up, of course, in this process. But another thing that I find that could trip us up, addition to a date issue, would be, what are you challenging? We'll get to discussing probate versus non-probate assets in a little bit, but for now, are you challenging the construction of the document or the actual validity of the document? And that is actually kind of a tricky question. So I wanted to point out a couple of things that our cases are saying about that in case we're faced with the way your client comes in and what exactly your client thinks is wrong actually dictates what you'll do. A lot of attorneys don't do this on a regular basis, and quite frankly, most attorneys don't do this on a regular basis. There's not a lot of caveat proceedings going around. You can tell by the lack of cases in the Court of Appeals that there are not that many of these challenges. So, by nature of the work, maybe some attorneys just don't have a chance to do it. But anyway, the point is, our Supreme Court has held that the construction of a will presents a proper judicial question under provisions of the Declaratory Judgment Act, which is basically pointing out that that is not a will caveat, right? By contrast, the caveat proceeding is a method in which we're looking at the actual document and determining that that document itself should be challenged because it's basically, this wasn't daddy's will, right? That's the essence, that's the essence of a caveat. So to compare the two, because this is one of the preliminary questions you're going to ask yourself, what exactly is my client challenging? So unlike the Declaratory Judgment Act, the purpose of the caveat is to determine whether the paper writing purporting to be the will is in fact the actual last will. Daddy revoked it. He didn't want this will. He had a new will that was after this one. So those are the times when you would do that. So then the court says the issue be whether the contested writing is the valid will may only be challenged by the caveat versus if there's something that relates to construction of an unchallenged will, it is done through a completely separate process. And so I'll show you, and this is an example, and this is a case that I'm referencing as well that gives this example. Your client was to inherit under a will, but the provisions that gave her anything in the will were actually blacked out, like literally took a Sharpie and marked it out, okay? Your client agrees that this actually was the will, but questions the fact that her provisions were blacked out. Daddy wouldn't have done that, right? And so if the provisions stand as the blacked out provisions they are, then she is nothing. And so this is what your client has presented you with. She wants to challenge the will, she says. She's Googled it and she knows there is a proceeding called caveat. And so what do you do? So this poll is up. Give you guys a moment to ponder that. Client says, Daddy wouldn't have put a Sharpie to the wheel and marked out my provision, you know? And of course, evil stepmother, this is how this obviously plays out. Evil stepmother says, of course, that's what he did. He didn't want you to get anything. He didn't like you anymore. Give you guys a moment to answer that. And okay, we have a 50-50 split. We always get excited when we have a 50-50 split. So 50-50s, half say do a declaratory judgment and half say do a caveat. Well, thankfully, we do have guidance from the court. The case that I was referencing gave this example, and this was an example when the parties were not challenging the actual validity of the instrument. They were challenging the construction, meaning the piece of paper was his will. So that means you do not file a caveat. So here, the answer is actually you're going to file a declaratory judgment action, not a caveat. And so in that particular case, the disinherited granddaughter, whose name and provisions have been blacked out of the will, had actually filed a caveat. And the court said that that was inappropriate, and they actually dismissed it. And so now we all have learned from their mistakes. And so we all now know that if your client comes in and says, this was daddy's will, but it was manipulated, and if he blacked out my name, he did it under undue influence or duress or whatever. But the will itself is good because daddy did the will when he was competent. The witnesses were there, everything was fine. That is not a caveat proceeding, okay? We all clear about that? Any questions about that? Okay, great. So back to our original question that we put a pin in till now was the time frame. He comes in and, if this is human, like this is sort of sometimes we get frustrated with our clients, but we kind of need to go back and put back in the humanity of, well, why did you wait so long to come to me, blah, blah, blah. Well, again, anytime we're dealing with an issue like this, someone has died who you were likely the heir, the client was likely the heir, so there might be emotionalism and so forth attached, person died. That's one. The other part is simply not knowing what is going on. It is possible that someone told her that she was going to get something, and later on throughout the probate process, she realized that she wasn't. Because then she's now, I guess, on, in essence, constructive notice. So she then has a time period. So at the time of application for probate, or any time within 3 years thereafter. So we're looking at the time they applied for probate, which actually I should have put another option on there to point out that it's not from the date of death. And so some people misunderstand that because evil stepmother might have waited 8 months to file the probate, right? And so it's at a time of application for probate of the will or at 3 years after that. So be careful if your client comes in and says, daddy died 4 years ago, right? Don't throw up your hands. Oh my God, you waited too long. We can't do anything, right? That may be true if we're dealing with some tort claims, which I'll talk about in a second, but if we're dealing with a straight, you need to challenge this will because this is not his will, then saying daddy died 4 years ago is not an automatic, it's over. Okay. Because actually, evil stepmother may have waited another year to have filed the probate. So that is just check on that. But the other part is the person may file a caveat within 3 years after the removal of a disability. Disability in our context was they were under the age of majority. So daughter was 17 when daddy died. Evil stepmother gets her out of the will. Daughter couldn't have done anything at 17 anyway. And so 3 years after the removal of the disability, which means 3 years after reaching the age of majority. So you see how that elongates your time as well? Because daughter dies, daughter was 17 when daddy died. Okay. And so wife, evil stepmother, immediately probates the will, which ordinarily would have triggered your 3 year time frame, right? But because daughter was 17, she gets 3 years from reaching 18. So this could elongate it significantly if you think about it, because my example, I'm saying she's 17. What if she was 15? Daughter was 15 years old, and she reaches the age of 18, and then she has 3 years from the age of 18. And that makes sense, right? Because what 16-year-old or 15-year-old can go to the courthouse and say, I'd like to see a copy of my father's will, right? And so you get eight. So that actually would be an example in which your client comes in and says, I want to challenge something. And you say, when did daddy die? And she says, 6 years ago. And you do not throw your hands up and say you can't help her. You say, okay, wait, how old were you when he died, right? Okay, great. And of course, incompetence is another one. So that's sort of probably not the usual example. The usual example is what I was saying, but let's throw out incompetence as well in case there was a reason that your client didn't have the capacity to engage in this process. At the time of the probate, you still get 3 years from when the client was deemed competent. So FYI on that. Can you have the caveat proceeding as a jury trial? All right. Your client certainly thinks this is salacious and interesting, and so they would appreciate having a jury to understand the plights that they're facing. So is that possible that you can have this proceeding as a jury trial? Okay, thank you. And 22% say yes, you can have that jury trial. And the answer is that is correct. So you 22% were correct. Upon the filing of the caveat, the clerk transfers the case to the Superior Court for a trial by jury. And so that's when you have a factual issue, of course. We'll talk in a moment, thinking about times in which the judge actually needs to make a decision. We're talking about our motion wars, when the other side motions to dismiss or summary judgment. Certainly, those when there's no debate of facts, then it doesn't need to go to a jury. But some of this stuff can sound very fact based, and so that finding of fact is appropriate before the jury. Okay. So, interested parties have 30 days to file a response to a caveat proceeding. So, of course, your client comes in on day 45. So, what do you do then? Your client walks into your office. Now, just for clarity, your client is the executor of the estate, right? Your client is saying this is daddy's will. okay? And your client walks into your office and says, 45 days ago, I was served with a response to a caveat. I was served with a caveat proceeding notice. I was so upset, I couldn't do anything to 45 days. So now I'm in your office. So are the regular rules of procedure going to apply and your client is in um, a very bad position, or can you do something else? Can she still deny the allegations, or is she deemed to have admitted the allegations because the 30-day response period has expired? And all of these situations are very realistic, by the way. I mean, for any of us who practice, we know that our clients are going to give us, you know, some work to do. All right, so I guess that was an easy question. Everybody agrees that she can still deny the allegations. That is correct. And the caveat proceeding, this is a slight deviation from like the regular rules of civil procedure. She still, you as the attorney, still should file the response and deny the allegations. You can still do that even though it's outside of the time frame, and the court doesn't follow those same rules as far as deemed to have admitted if not answered. So that's good for your client, right? So here's the rule, the actual statute. Within 30 days, following each of the order, which is what you should do. Obviously, our goal is to follow the rule and not seek to find an exception. But again, this is a scenario where our client created the situation. They're going to file a response. However, that failure to respond to any averment or claim of the caveat should not be deemed an admission, right? So, truthfully, some attorneys have interpreted that loosely to mean that you don't need to file a response. Well, technically, what is the value of a response? I think the value of the response is actually preserving my record. So I would do that, but I do recognize that what the statute says. So to me, my goal is to hit the 30 days. If not, I actually do go through the process of if my client comes in, file extension of time, get it in the file because I anticipate it going to the Court of Appeals and wanting to have a nice record. But again, not the end of the world because you can see that it's okay. All right. So my client believes that a caveat proceeding was filed in bad faith. You represent the executor, right? She's this that van from that vantage point. This is a ridiculous waste of our time and money. But the important part here, and it will result in your client, who's the executor, and the estate losing money. So client comes in, she is furious that this crazy daughter has filed this proceeding against her, right? She says, if I can't move forward, we're going to lose assets. Think about there are a lot of businesses that the decedent could have left behind. So there are moving parts with the assets. There are just things that are happening. And she says, what does this mean that I can do? So, do you wait until the end of the litigation and seek damages, or do you request the court order that the caveator put up some money to protect your client's interest? Because generally speaking, we would just wait till the end, right? Because if it's really deemed to have been found in bad faith, it is possible to get your attorney's fees. It is possible, depending on the level of egregiousness we're dealing with, it is possible to take it up even another level, right? Maybe there are sanctions, perhaps. But when do I do that? Okay, 90% are saying request a court order the caveator to put up some money now, and that would be the best strategy for your clients, and it is allowed by statute. Upon motion that you're going to file a motion requesting this, the court may require the caveator to provide security in such sum as the court was going to deem appropriate to protect against for costs and damage that may be incurred. And so that is an appropriate thing to do. So excellent way to achieve your client's goals. So then my client is the person representative of the estate. Before she had the opportunity to file the taxes for the estate or pay for the funeral bill, the caveat proceeding is filed. As a general matter, we know that the caveat proceeding is supposed to halt the estate proceeding, because if, like, I mean, it's obvious. Like, why would you let the executor continue to work on the estate and distribute assets if the end result of the caveat proceeding is that the will is not even the right will? So, of course, they must stop what they're doing. So, I know that the proceeding basically stays the estate matters, but can she at least pay the funeral bill and the taxes? Maybe things that aren't in controversy is kind of what I'm thinking about, right? Like, if we have estate taxes, we know there was a funeral bill. I mean, come on, right? Or do I halt everything? Right, poll is open there for you guys to ponder that. Choices are: did you file anything? Then it will be no, not until the caveat is concluded. Or yes, you can file the taxes. Yes, you can pay the funeral bill. Or yes, file the taxes and pay for the funeral. Okay. All right. Well, there's a little bit of a division here, but the majority of you guys are saying she can file the taxes and pay for the funeral. You know, I actually was expecting a different answer in the statute, because I was thinking it is possible that the taxes could be an example of something that is controversial. The funeral bill could have been extraordinary, and for some reason that could deplete many assets of the estate. I was thinking about that, but the majority of you are correct in that the statute does allow for you to pay the taxes, file and pay the taxes, and it allows you to pay the funeral bill. So you are correct that those are appropriate things that you can do, even though the caveat proceeding has taken place. And so it's good to know that, because I think if I represented the representative of the estate, and at some point there's an argument that my client wasn't doing things properly, I wouldn't want the other side to be able to also say, and she didn't even file the taxes, and she didn't pay the funeral bill. And so that really doesn't help my client. And so I think that it would be appropriate for us to make sure our clients were aware of that and at least knew that they had some duties and obligations. So the other thing that comes up, and just kind of how this works, is I call it your secret love child statute. And so the statute says any afterborn, after adopted, or entitled afterborn child born out of wedlock shall have the right to share in the testator's estate, to the same extent the afterborn or after adopted or entitled afterborn children out of wedlock would have shared if the testator had died intestate, unless, and I know a lot of attorneys are putting these provisions in their wills, because it just protects your client from such situations. And I had I was trying to remember how many times this has ever come up, but I did have it to come up once, not in a caveat proceeding, but in a will consultation. My client and his wife were sitting there meeting with me, and they mentioned that he had had a child from an affair that he had on her. And of course, I obviously wouldn't have known that. And so it wasn't me who brought it up. And it was really great though, because he brought it up and he basically, I mean, I don't, he brought it up and basically, as you can imagine, because his wife is sitting there, they didn't want that particular person to inherit anything. And I thought, man, I was pretty surprised that they had the wherewithal to bring this up because I would have not known and I would have missed it. My questionnaire doesn't say, do you have any illegitimate children that we need to talk about? It doesn't say that, although perhaps it should. So anyway, and so I explained to them that they have to basically acknowledge the child in some form of fashion to meet one of these exceptions. So look at the exceptions. The testator made some provision in the will for the child, whether adequate or not. Now, this sounds mean, but again, my job is to achieve my client's goal. So how do you meet that exception? This is where you give that person $1, and it is what it is. So illegitimate child, after born children, assuming that that's what they wanted to do, or after adopted, whatever, if you give them the $1, then they can't claim any other money from the estate. So another exception is apparent from the will itself that a testator intentionally did not make specific provisions therein for the child. So there you say something else that might sound mean, but it achieves the objective. You say, I am aware that I may have other children and I am choosing not to provide for them. I think that's what they opted for instead of the $1, actually. But again, that's their goal, that's their objective. It protected them from a potential claim against their estate. So the testator had children living when the will was executed, and none of the testator's children actually take on the will. That seems more than appropriate. If I didn't give to the children that I knew about, then I certainly wouldn't give them to the children I don't know about. The surviving spouse receives all of the estate under the will. So this is great, especially for those of us who prepare what we call complementary wills. And that's when the husband and wife come in and they do wills that complement each other. And so in those situations, husband says, if I die first, everything goes to wife. And wife says, if I die first, everything goes to husband. And then whoever is left, they come to an agreement about, okay, so now when both of us are gone, Sally gets this and Billy gets that and Mikey gets that. So, and that's generally what I'm most comfortable doing with a married couple and acknowledging. I acknowledge because I think I have to because of ethical rules that they can't come back to me individually and change that. They can go to someone else, which is fine. I mean, it's not fine, it's legal, but they can't come back to me and say, oh, by the way, change this will because my wife is dead now and I don't want her kids to get anything. I wouldn't be able to do that. But I think you actually can totally do that, honestly. But anyway, the testator made provisions for the child that takes effect upon the death of the testator, whether adequate or not. All right, so let's get to our cases. So here, the husband owned property and then married the wife. Some weird stuff happened, which I'm not sure is totally relevant. He owned the property prior to marriage. Then they did something to put her on the deed. Then it went back to him. It was very odd. But anyway, the ultimate point was that the will was created and left all of the property to her, the wife. So then the wife had a son, right? After the will was done, obviously, this is before the husband died, of course. But in the meantime, obviously, the husband does die. So, wife had a son that the son that's their biological kid. Son grows up, reaches 18, and then at the age of 23, he's like, "Wait a minute, um, I'm going to challenge this, right?" And you're thinking immediately about an SOL issue, right? Which is one of the challenging ones because the son was very young when his dad died. It was actually not challenging, it's just long. He might have been like 7 when the dad died, but we know the statute gives you 3 more years. But in any event, he filed the action at 23. So she first makes an argument. It was a super complicated situation, but she makes an argument. Well, excuse me, not she, he's the one suing mom, argues that his claim is without any time limit, because it will result in a cloud on the title of all of the property in the will. Okay. And so, therefore, that means that the statute of limitations does not apply in this situation. You knew there was going to be an argument about that, right? You knew he wasn't going to file a lawsuit 2 years too late and pretend like hope nobody noticed. So, of course, he has an argument. He says it's ongoing. There is a cloud on the title which needs to be cleared up, and therefore you can't just ignore clouds on title. So that was his argument, which I actually thought was pretty clever. So he says his interest vested. Oh, this is the other thing I thought was good. He says his interest vested at the time of his father's death, and therefore the statute of limitations is not a bar because forget what wife is saying. When dad died, as his heir, I immediately received an interest in the property. And so, regardless of when I seek to file the caveat, the SOL is not applicable because I am simply defending an interest in property that I already have. Doesn't that sound like a clever argument? I thought it was very clever. I like clever arguments. So the court said, look, that's not true. Okay. Basically. Plaintiff was not immediately vested with a one-half undivided interest in the property at the time of the father's death, and therefore 3-year statute of limitations is a bar to his claim, and it will simply be unreasonable to allow plaintiff's claim to proceed. They added this after such a long delay. I felt like reading that last sentence that the court didn't like. It wasn't just 18 plus 3, because that's only 21, right? So really, long delay is that are they talking about the 2 years, or are they talking about the fact that the dad died when he was 7, so that was 11 plus 3 years, and so he had a 14-year period, basically, that he could have filed the action. And I think that's what they were referring to. So when you add all those things together, the court really doesn't appreciate that. But that argument that property really did vest in me, it sounded really good. I can imagine I would have made that argument too because I had no choice. My client came to me 2 years too late, but now we know that it's not a good argument. So no, I wouldn't do it. So there you go. So in our next case, siblings have a dispute over the proceeds from savings bonds. Now, I could think they're all fascinating. So this is fascinating as well. So savings bonds were deposited into an account. And the deposit account where the proceeds from the saving bonds were placed was owned by the mother and the defendant with a right of survivorship. See the twist? And so the other siblings were like, no, we want our portion of those savings bonds. Can this dispute be resolved in the caveat proceeding? Because the siblings they basically want to pull those funds back into the estate, then challenge the will because for whatever reason. But yeah, the issue is the savings bonds were at the time mom died, they were in an account that mom and daughter had together with a right of survivorship on the account. Okay, give you guys a moment for that. Okay, thank you. And the majority of you are acknowledging that those proceeds were never part of the estate. So, thinking about that case and then comparing it to the previous case, we're starting to see how the court is viewing assets. So, if the decedent had a bank account that had proceeds and it was labeled mom, daughter, and right of survivorship was attached to the account, when mom dies, you are correct. Daughter immediately gets the money in the account. So therefore, when whoever went to probate the estate, daughter, those savings bonds are not subject to the caveat proceeding. Even if they win the caveat proceeding, they do not get those savings bonds. So the court has recognized that while the claims arise from administration of an estate, their resolution is not part of the administration. Sounds very technical, but it's true. There are estate issues, but you have to have a probate asset, right? And so and that was, and of course, the attorney had filed the caveat to get the savings bond money, and that was not correct, and they shouldn't have done that. And so, not to beat up on our colleagues, but we kind of can see we have the benefit of sitting at our desk and not arguing with the client, so we can kind of see it a little more clearly than the attorney did. Same thing with life insurance policies. Okay, so life insurance proceeds with named beneficiaries are not part of the state administration. Apparently, there are life insurance policies that don't name beneficiaries, and so that actually is a caveat. If you run across something like that, that does become a probate asset. I never thought about that, but I suppose it makes sense because the money has to go somewhere, and so the money from the life insurance policy would go to the estate if it didn't have named beneficiaries, right? Cool. So the other thing that I want to point out is, so go back to this idea that daughter did something really bad that convinced mom to sign this account where that gave daughter right of survivorship. First of all, daughter, pretty smart move, by the way, because you're shielding yourself from a caveat proceeding. This is true. But I want to point out that there are also really great tort claims out there that you can file separately. So know that as well. The case is not over. You can't trick people. You can't trick people out of their money, and I'm just going to let it happen. I'm not going to let it happen. Okay, so that's one. Also, know that there may be viable claims to pursue the life insurance proceeds the same way, even though it's a non-probate asset. You can't do it with the caveat. So, same thing. If there was an agreement, if there was fraud, if there was unjust enrichment, if there was some level of deception somewhere that you can allege that it was not a proper, mom didn't know what she was doing or tricked or whatever, those are still viable claims. So I don't want you to walk away forgetting that. This is just a CLE about caveats. And so we're focusing on what you can do in an actual caveat proceeding. Right? Okay. So in our next case, the wife died and the clerk accepted this holographic will presented by his girlfriend. Wait, did I say that wrong? I think, I don't know why I switched that. It doesn't matter what their gender is. Anyway, this person died. They weren't married is the point. And so I think it was a husband, but it doesn't matter. Oh, W. Worley. That's what it was. Sorry. I was like, why does it say W? I usually say that when I mean wife. Anyway, either way, the same concept. His siblings come forward and say, this isn't his intent, yada, yada. You know how it goes. So the clerk determined that the holographic will reflected his intent. The siblings appealed and won in Superior Court, and the case goes to the Court of Appeals. All right. So actually, the thing that I want you to pick up on, which I'm sure many of you did you notice that the clerk had actually made a determination? How did that strike you as odd, or did that strike you as appropriate? So give you a moment to think about that. What was the clerk supposed to even do that? Listen, you guys are so on top of things. You remembered, or you already knew from the beginning of this discussion that the clerk is supposed to immediately transfer those disputes to Superior Court. So that was completely inappropriate. So very good. The clerk is not supposed to do that at all. And some clerks do, as you saw in this case. So the matter must be transferred to Superior Court to resolve it. Upon the filing of the caveat or raising an issue, listen to this, I thought this was good, or raising an issue of the intent. So the clerk is going to transfer the case. So the important part here I wanted to also add, you all knew that the clerk is supposed to transfer the case. But the other thing is, if your client did not file a caveat, but went to the clerk and raised issues of the intent of the party, which is the decedent, the clerk still has to transfer the case. So this is not something the clerk has authority over. So then if the sibling had not filed a formal caveat but raised the issue of testimony intent, does this still divest the clerk of jurisdiction? Well, I kind of already said that, so I'll skip that poll. The answer is yes. Everyone follows that? Even if your client comes to you and says, I provided documents or whatever I did to let the clerk know that I do not believe this was daddy's will, that divests the clerk of jurisdiction, and any ruling that the clerk made really should be set aside, period. And so the judge in Superior Court really should disregard whatever the clerk did and make a proper ruling. That's what you should push for. Okay. Since the sibling had raised the issue, the clerk was correct, ultimately concluding that the clerk lacked jurisdiction to decide the issue. So here the clerk did the right thing, ultimately. So Supreme Court judge now move on past the clerk issue and let's get to the meat. The Superior Court judge can decide the issue without a jury if there is no material issue of fact. So this document said, last will of Paul Worley. This is handwritten. I want Pat's spouse to have the power of attorney of all that I own. That means land, cars, money, guns, clothing, and anything else, exclamation point. I don't want Grace Price Worley to have none. Signed, dated, he thought making it in time, made it official, and he signed his name. Okay, that was it. Is that, well, you know the question, was there a material issue that is being raised that this document was meant to have testimony intent? Because if the judge said that there's no issue, the judge is going to make the decision and it's binding. But if there's an issue, the judge is going to send it to the jury. Oh, wait, that's the right question. Oh, I'm sorry, hang on. Oh, sorry, not that question. We skipped that one. Sorry. Let's go to the question, was there a material issue? Okay. Now this pulls up, was there a material issue? Yes, there's a material issue. No, there's clearly a power of attorney. No, this is clearly a will. And the language was, I want Pat to be my power of attorney. She gets my guns, my clothes, and anything else. And I don't want my daughter to have none. All right. Oh, okay. Thank you. So 90% say there is a material issue, but some of you, 10%, say this is actually clearly a power of attorney. And I thought it was interesting. Nobody thought this was clearly a will. Let's go back for a second and look at that language. I'm interested. Nobody thought this was a will. He says, I want her to have the power of attorney of all that I own. That means he explains it. But then I don't want Grace to have none. So nobody thought that Grace having none of his stuff, I assume, right? And look at the top. His handwritten words said last will of Paul Worley. Interesting. Nobody thought that was a will. Interesting. Okay. Well, let's see what the court said. The court said in the present case, we conclude that the jury could reasonably infer from the language that he intended the document to be his will. For instance, it was literally labeled last will. And so the court said, agree with you 90%, that said there is a material issue there because he's using language of power of attorney, but he's also uses language of will. And so a jury could decide either way. All right. So now, does the language, so does this language raise a material issue as well? It says, this is, again, this is all handwritten. It says, this is to certify that I, Mrs. Seymour, do this day invest my husband with full power of attorney over all of my property for the purpose of acting for me in all my business matters. This also constitutes my last will. And she signed it. And yes, I know it would simply be better for everyone to just come to us for services, but they don't. They Google it, they write down something, and this is what happens. So she said, this also constitutes my last will. Does that magically make it a will? Or is it still debatable? Or is it simply not a will because she's talking about a power of attorney? Where do people get this stuff from, man? Because even if you Google the form, it wouldn't. If you Google the form, it wouldn't say this. But nevertheless, we can't speak ill of the dead. All right. So let's see. 70% of you guys say it's debatable, but 20% actually say it is clearly a will. You're tainted by my last fact pattern. And then 10% say it is clearly not a will. Okay. So this one, the court said actually the court agreed with 10% of you guys. The court said this is clearly not a will. Now, what was the difference in the two? The biggest difference that the court took away when they said the document that you labeled, this is my will, and they said it's clearly not a will, the biggest issue the court had was that there was no disposition of assets. She didn't say, let's go back to the language, in fact. Now, she says her husband is going to be a full power of attorney over all my property and business matters. And this constitutes my last will. But it doesn't say that her husband gets her property. See the problem? She never says where her property goes. Go back again. Let's go back to the previous example before that. He says, Pat gets all my stuff, my cars, my home, my money, my guns, and Grace gets none. And by the way, someone made a comment on our Facebook group how he says, I don't want Grace to have none, that was a double negative, and one of the court is going to interpret that literally. No, they're not. We know what he meant, you guys, you English majors. But anyway, so you see how he put in a disposition, but then he also put in power of attorney. That created a viable question. Then we go to the next one. She basically said, you're of the power of attorney, and then this is my will. But where does my stuff go? And without that, the court said this is not a viable question. This is absolutely not a will, okay? So, which means if your client was the caveator, they win because the caveator is saying this is not daddy's will. And here they won, and they won it on a bench motion, not before a jury, because the court said it wasn't a viable debate. Okay. So we're wrapping up. Hang on, got a little bit more to talk about. Matter of the will of Allen. The will had handwritten notes, and the question in the caveat was whether the handwritten notes constitute a holographic codicil. Okay, you prepared this amazing will. Your client goes home and makes notes on it, and changes stuff. And apparently doesn't want to hire you to do the codicil. Okay. Oops. Oh, shucks. I made this bigger. Sorry. All right. So basically, sorry you can't see it. It actually says that there's a provision at the top. His handwritten notes there are saying he doesn't want the person in this article to get anything, basically. Okay. So the article above says Sally gets stuff, a whole bunch of stuff, actually. Right down below that, he says, I don't want this provision to be enforced, and then he signs it. Okay. So the evidence, when viewed in a light favorable to the non-moving party, the court says clearly indicates that the will, including the handwritten provisions, was found among his stuff. So when he said, do not honor this article, void this article, initially the trial court was like, yeah, but you can't have a codicil that refers to the type part. The codicil has to stand by itself if it's a handwritten holographic codicil. So the trial court was like, well, the codicil needed to say, I don't want Sally to get anything, period. And that could be a holographic codicil. The Court of Appeals like, well, we know what he meant. And he's not necessarily first of all, we know the policy is always follow the intent of the testator, right? And so his intent was very clear, do not honor that article. That article was the only provision that gave Sally something, and he said don't honor it. So the Court of Appeals then said that evidences a clear intent regarding desire of disposition for the items in Article 4, and they were going to honor that. So he did not, the court said, and this is like a new thing because even the trial judge said it, the Court of Appeals said it. Well, the Supreme Court said that the testator does not need to rewrite Article 4 in the handwritten codicil for it to be effective because that was the original interpretation. And so they honored that holographic codicil, even though in the past it had appeared that the rule was that you couldn't reference a type thing in your holographic codicil because the codicil, it was holographic, need to stand on its own, right? All right. Okay, we're going to basically have time to do this. So X has been deemed incompetent to deal with the affairs, and the guardian has been appointed. X is deemed incompetent to make a will, and is there only a rebuttable presumption that X is incompetent? Last question, okay? The person was deemed incompetent, like a guardian was appointed. Is that incompetence for purposes of will making as a matter of law, or is that a rebuttable presumption of incompetence which could be overcome with evidence? Okay. And the majority, you guys are really on top of this today, I'm telling you. The majority of you guys are getting it right. 70% say it's only a rebuttable presumption. Isn't that interesting? And that is correct. It is only a rebuttable presumption, which means if you have the energy and the fight in you, you actually can make this argument that my client who was deemed incompetent actually was competent for purposes of estate planning, and you could actually prevail against the caveator. I think that's fascinating. But anyway, it seems like, I mean, you have a pretty stiff burden, right? Because it is a presumption and against your position, but it is rebuttable. So at least know that it is rebuttable. So lastly, as we're wrapping up, I just wanted to hit on how sometimes when a caveat just won't do, when that's not going to give you enough of a remedy, the court is okay with you filing a torts-based claim against whoever, right, against evil stepmother or whoever it is, and filing a caveat, because the caveat will only set the will aside, right? Your client files the caveat, but what about, just like we talked about earlier, what about those non-probate assets that evil stepmother was able to get from your dad? That still needs to be addressed, but it can't be addressed in the caveat. Only thing the judge is going to do in the caveat is say this will is invalid. And then you go back to the person being intestate, or maybe there was a previous will or whatever. That may not address all your issues. So just know that there's a lot of authority that says you can file that torts claim and it's not going to be precluded, because the caveat was not designed to get you your triple damages or deal with non-probate assets. So understand, so wrapping up, the takeaway is, if someone has really done something to your client and taken away assets, if you find that there are probate assets that need to be addressed and then there are non-probate assets, you're filing two actions. You are going to do the caveat to set the will aside, but then you're going to file a torts action as well, and you can actually do both, okay? All right, there you go. We met the hour right on time, people. Now, any questions as we wrap up? Thoughts, comments? Hearing none, I will say thank you for participating today. We appreciate you joining us. I hope you've learned something, enjoyed your time, and I hope you have a wonderful, wonderful Friday. Thank you.